So good morning, guys. And so hi, I'm Rohit. Many of you will be seeing me for the first time. Some of you have attended other webinars with me, like privacy engineering or maybe the Saudi bootcamp session. Here we are with another webinar, Tsaaro webinar, where we'll be talking about CPRA and especially in terms of its deadline and the checklist for it. We'll also be going how we'll conduct it is we'll be comparing it thoroughly with CCPA, which has been there. And is this a replacement for CCPA, or is it adding to CCPA? How it is going? So this is how what we'll discuss in the webinar. So let's move forward. For the webinar, we have Ujjwal with us, who is a very senior person in the privacy field. So Ujjwal, would you like to introduce yourself?
Hi, good morning, everybody. It's nice to see that, all the privacy enthusiasts are flocking for this webinar on this Friday morning, and an advance wish for a great weekend ahead. So, today's webinar is really a very important piece of legislation, which is going to come from 1st of January 2023. However, it also got good lot of nuances attached to it, as because that is going to amend our existing privacy legislation. So before we go into that in details and have some interactions with the participants, so just to give a brief introduction of myself, I'm Ujjwal. I'm a professional lawyer, but I'm also a privacy enthusiast. And for last around 6 years, I'm intensely working on privacy, data privacy, mostly from the legal perspective, mostly on GDPR, CCPA, and few other significant privacy legislations. I'm presently working as Director, Legal and Compliance of PricewaterhouseCoopers Service Delivery Center, Kolkata. I'm based out of Kolkata, the city of joy. And let's all enjoy and celebrate the new legislation which is going to come, and let us have a intense discussion, some brainstorming on the legislation, so that we all can be ready for the day one for 1st of January. Thank you. Over to you, Rohit.
Thanks, Ujjwal. Thanks for the introduction, and it's great to see you here.
Thank
It's
you.
always good to bring knowledge from the most experienced people in the industry, and especially who can see what to say privacy programs as a whole, not just as a on a very activity based level. So, guys, as for me, who do not know me, I am a director in Tsaaro for solutions and technology. I am a cloud solution architect, so I'm a techie, but I am also inclined towards privacy. So, how you can put me as a privacy solution architect or a privacy engineer? That would be the term that you can use for me. So, moving ahead. So what does Tsaaro do? So Tsaaro is a data protection service provider, data protection, that is security and privacy. And we help organizations comply with build their privacy programs, implement security solutions, comply with the ISO. So these are some of the things that we do. In this webinar, as always, we as the speakers are only presenting our views, and this webinar is only for educational purposes. It's not a legal advice, and we are not representing our organizations when we are discussing any point in this webinar. So the agenda for today is, first we'll briefly go through what is CPRA and how does it stand with CCPA? What does it add to it, removes from it? And then for the additional part, we'll discuss what is there and how can we contain that addendum through a checklist. If there is a non-compliance, then what happens? What data is in scope? So this is what we'll be discussing, and in the end, we'll be leaving you with a checklist with the differences between CCPA and CPRA, so that it creates an impact in your brain. And whenever people are asked, you can just refer to this slide. Okay, boss, this is how it goes. So let's begin, Ujjwal.
So thanks, Rohit. Thanks a lot for the intro. And one very important aspect to touch base, that is the holistic understanding of a privacy legislation. And this wholesomeness or this holistic approach is quite significant for CPRA. This CPRA is the California Privacy Rights Act 2020. In fact, just to give a background, why I am telling that a holistic approach is quite important for this, for studying and finally to arrive at and to craft certain checklist so that we remain compliant vis-a-vis CPRA is important. The reason being, CPRA is not only a amending act of CCPA. I'll come to that. What is CCPA? But another very important perspective, which I gather when I was preparing for the notes and all for this webinar, I could find that CPRA is an act which is going to bring certain very significant aspects of the European data privacy legislation that is called GDPR, this General Data Privacy Regulation. GDPR, which is the most significant self-regulated piece of legislation for Europe, which is governing 27 EU states. It got some most advanced and most rigorous legal provision vis-a-vis data privacy or information privacy is concerned. So CPRA has brought those things, and those have been plugged in various places. And the very object is that twofold. One, to strengthen the rights of the consumers, and two, to make the business more responsible towards the informations of the consumers and households of California, which they hold. So just the background, the first, that California Consumer Privacy Act, or CCPA we call, that is of 2018, that is the present California legislation of privacy. Now, why California, not any other US states? California, which houses the Silicon Valley, so there the organizations are holding a humongous volume of data, maybe personal, maybe non-personal. So California as a state, as a US state, had also been very progressive in drafting and in having this kind of privacy legislation, and CCPA being one of the most advanced. Now, CCPA came in 2018, rather CCPA, the act is dated 2018, and the CCPA came in January 2020. Now, the gap between 2018 and 2022, this gap, the technological advancement made in between, perhaps that is going to be abridged by the new act called CPRA, that is California Privacy Rights Act. And the California Privacy Rights Act is going to amend some of the provisions of CCPA, but that is not going to replace CCPA. Both acts will be there side by side. So here, when we are speaking about the very important deadlines or important dates, one here, which is already there in the screen, that
so Ujjwal, sorry to disturb you. So
yeah.
this is a live voting that happens,
Okay.
and the response that you're seeing are from the people attending the webinar. So on the screen above, you will see a code. So guys, you can go to menti.com and you can participate in this voting. And before you can give the answer to the people and they all vote. So I would like to know your views, guys. This is totally anonymous. Nobody can know where you voted, but this is just a general inclination how aware people are. So you can put it on 1st of January. Seems like a winner. it looks like people are moving towards that.
No, it's a good thing, that way with this interactive thing, and that's good, It's going to be a sort of live brainstorming for the participants.
Yes, it's a live brainstorming, and especially I like it when votes go this way.
Yeah, yeah, absolutely.
No, I think so. You have a thing to add. So, guys, please, I would say just take a note of the votes, how it has happened. 31st December 2022, 1st of January 2023, and 1st of July 2023. So, 1st of July has got one vote. Here we have five of them. So, let's move forward to the next slide. And Ujjwal, as you were saying, then we can have it discussed here.
Yes, yes,
Where does the act take effect and what is the deadline for the organizations? There are two
A-
different what to say dates here and two different activities here. So I
absolutely.
would like to continue. Sorry for cutting you short,
No, no,
but
no, not a problem. So here, if you see, so since we are now focusing mostly on the dates, so there would be altogether 3 dates, which are very relevant for this matter. So first date which comes is, which I've already mentioned, that is 1st of January 2023. As because on 1st of January 2023, most of the provisions of CPRA are going to be effective. However, there will be a cooling off period of 6 months, and the provisions which would be effective on 1st of January, those would be enforced on 1st of July 2023. And there is another very important date, and that makes this CPRA quite complex. That is, once this effective, once the this CPRA becomes effective on 1st of January 2023, there would be a look back period of preceding 12 months. That is, the businesses which are going to be covered under CPRA, they would be under a strict obligation to disclose how they have treated with the data of the consumers and household since 1st of January 2022. So CPRA is going to be effective on and from 1st of December, 1st of January 2023, going to be enforced from 1st of July 2023. However, that there will be a retrospective effect under which business would be under obligation to disclose how they have dealt with the data belonging to the California residents, effective 1st January 2022. So these 3 dates, which are quite distinct and quite significant vis-a-vis CPRA is concerned.
so guys, just to sum it up, 2022 1st Jan is the starting for the data belonging collected after that falls into this 1st of January 2023 is the date when the law comes into effect. July 1st is the deadline for the organizations. Do not get confused because we say that it's a 2020 law. That's why sometimes it feel okay ये वाली date हो सकती है, but it's not that.
So ultimately, what it boils down is this, that if there is an irregularity for a data or for personal information for, say, around March 2022, after 1st July 2023, that irregularity will also fall. Irregularity at the end of the business will also fall within the fold of the regulator as a non-compliance. So this, this correlated dates makes this CPRA quite complex and bit that way, and we need to exercise utmost caution for this, for the compliance, and particularly aligning these dates and aligning our strategy around these dates. So, Rohit, for the interest of time, we have almost
What
discussed
you said.
Yeah,
Yeah.
almost discussed what is CPRA, how that is related with CCPA. Now, the most important thing, that applicability of CPRA. Now here, before going into the very threshold, which is going to make CPRA applicable to a specific business, I just would like to say one thing, that is like GDPR, which got a transboundary application. CCPA as well as CPRA, both will have a transboundary application. Like, say, for example, give an example, a business which is being held at Mumbai, housed at Mumbai, based out of Mumbai, and having no presence within the jurisdiction of California, but that business is collecting data belonging to the California household or California consumers, and they are qualifying the three criteria laid down ABC, then that will also fall within the realm of CPRA or CCPA compliance. So that is the reason, just like that happens for GDPR. If an Indian website organization, if an Indian organization by through its website is targeting the residents, they who are in EU, European Union, then and having no presence in European Union, but still the GDPR is going to be applicable for CCPA, CPRA as well as CCPA, the very same principle apply. So we need to be very cautious whether we are collecting in our normal course of business, if we are collecting the personal information belonging to the California residents, and it might trigger the compliance. So we need to be very sure about this.
So since we are comparing it to GDPR a lot, so guys, you might feel that okay, Europe, when you're talking about GDPR, it's applicable to the European Union, which is the largest trade bloc in the world. Does California, not US, just the California fits into? To those people, I would say just go and look at the size of the Californian economy. What it is. It would
And
fit
predict
if
what is the
California
Silicon
was a
Valley.
country. Yeah, if California was a country, it would still fit in the top 10 economies of the world.
Absolutely.
So
The
I
highest
think,
number of tech companies, the highest number of startups.
yeah,
Here in this slide, yeah, Rohit, we are going to touch
yeah,
base on two very important aspects, that insofar as the threshold is concerned, what changes have been brought by CPRA. So one thing, but before going to there, one thing, that both CCPA and CPRA is going to be applicable to the for-profit organizations. They who are either based out of California or anywhere, however, they are collecting data, which I said, data belonging to California residents or California household. Now, there are three more criteria. The first one, that the annual gross revenue need to be 25 million in the preceding calendar year. The next one, that the annual sale or buy or sale or share or in combination, that need to be 1 lakh or more of the consumer household. Now, it was initially under CCPA, it was 50,000. Now that threshold has been enlarged. The second one is that 50% or more annual revenue for that business is coming from either selling or sharing the informations, personal informations belonging to the California residents. Now, here one very significant aspect has been brought by CPRA. That is, under CCPA, it was only selling. But now CPRA has brought the perspective of sharing. If a business is sharing personal information belonging to California region, California residents, and not selling, that will also come within the fold of CPRA. You know, this direct sale, that was something which was very important aspect in CCPA itself, and the people we work, you know, for this network of companies where data are flown transboundary, and we use an instrument called binding corporate rule, that's called BCR. So that time we need to, when the CCPA and this selling came, the concept of selling, data selling, direct data selling came, we need to amend that BCR. Now we are again since this new aspect of sharing has come, so we are again keeping our finger crossed, we are making reviews that whether again we need to bring some changes to these agreements. As because why I am saying so, whenever a new law comes, then we have to introspect that what changes just to remain compliant under the law, what changes we need to do in our existing agreements. The existing agreements under which the transboundary data movement is happening for your organization, say for example. And that is particularly happens for the multinational organization working in different geographies. So here we are again, doing this review that after CCPA, after selling, now this sharing, so what we have to do next. Anyhow, now, Rohit, I think we can go to the another very important aspect that though we have touched base a bit, that what are the changes that has been brought by CPRA? Now, here, if you see the changes, one is, as I already said, the strengthen the rights of the California residents. Now, another very important aspect is coming that, as I said here, this CCPA, few of the important perspective of CCPA is being amended or extended. Business regulations or the business are being is going to be made more responsible towards the personal information of the California resident data. And the fourth one, the most significant, that is establishment of CPPA, that is California Privacy Protection Agency. Here, I must say that this is something again which is bringing the California privacy regime more closer to the European privacy regime. As because initially under the CCPA, Attorney General was the enforcing authority for CCPA. But under CPRA, it's a very remarkable amendment being brought by CPRA. That is, our institution is now being given. It's a 5-member institution. And under this institution, there will be experts from law, experts from technology, experts from the consumer rights. They who are going to deal with various CPRA related issues. A privacy audit report need to be submitted to this agency. So this is something very significant, and I will just request all the listeners and the audience here just to give more importance on that, as because this is something which is giving a feel of that, like European Commission, the EC, that kind of an institution is going to be brought within the ambit of California data region. So we can move on, I think.
It would be great to see, even for example, because now we have a regulation body in these states now, so we can see now new privacy certifications, and especially from the level of applications coming up. So let's see if we have something like a privacy seal in Europe coming up in these states.
Yes,
So let's move
absolutely,
ahead.
Rohit, absolutely. That's because that is, linked with this adequacy decision, like whether data can go from, the one jurisdiction to another. Correct, absolutely.
And in terms of rights, guys, we'll be discussing the rights which have been added, so do not worry.
So, here you'll see these 9 significant changes. So I am going to touch base. The most significant was as because, this CPRA is so complex, we cannot discuss the entire, all the nuances that way in this 1-hour webinar. So the very significant one, which I would like to stress on. The first one is the threshold change, which we have already discussed. This, from 50,000 to 1 lakh and introduction of sharing. And in addition to selling, apart from that, another, the number 2, this CPPA, which we already also discussed. This is the new institution which is going to, adjudicate on the disputes, adjudicate on various issues under CPRA. Another very important aspect is going to be this cybersecurity audit. This cybersecurity audit will be a binding responsibility for the companies, they who are holding various high-risk data. And those high-risk data, is going to be something which will become under point 4. But those companies need to do a privacy audit. And we need to be mindful that doing our periodic privacy audits, now it's going to be annual one. the organization need to put something in their checklist so that the organization in a position to comply with that kind of audit, face the auditors, because that is going to be, and that audit report is going to be submitted to the CPPA. So they might be asking questions. So that checkpoints, that controls need to be in place so that the organization can do a very methodical, so kind of a very, an in-time audit, and they can collect evidences to in support of, to substantiate their audit findings, so on and so forth. So that's a very important. Now, another very important thing, this new category of information, a new category of personal data. Again, this is very, very close to GDPR, as I keep on repeating that CPRA is bringing quite a few very important aspects of GDPR into this regime. So, insofar as this, when I was just preparing the note, I could find that under this sensitive personal information, few of the data have been categorized, like biometric data that identifies a particular consumer, or like the genetic data, or racial or ethnic origin of an individual, or religious or philosophical belief, union membership. So these are, and significantly, these are also treated as sensitive personal information under the Indian bill, also under the new bill which came a few days back. And this time, CPRA has granted right to the consumers to tell the businesses not to share this SPI, that is limiting kind of a obligation on the part of the business to be very responsible while dealing with sensitive personal information of a consumer. And even they can limit onward sharing of that data to the third parties of the contractor. Rather, here, in normal parlance, we say the purpose limitation. This way, semblance of purpose limitation is going to be brought here. That is the very purpose for which this SPI is going to be collected by a business. The business cannot deviate from that. And while if at all the business is going to share that SPI with third parties for some business reason, then there should be consent from the consumer. So this is another very important perspective, that when the consumer is going to exercise their discretion, or rather their right over their SPI, the business should be able to do that. That is, there should be inbuilt control. Like when the business is going to share the data with third party, there should be something either automated or manual or whatever, that the business, that particular consumer should be approached for their consent. Or if the particular consumer wants to get the SPI deleted or rectified from the books of the organization should be in a position to do that. So
This is more this
yeah,
is more related to the data subject rights which were given under the GDPR.
absolutely have coined the absolute thing. We call it data subject right under the European legislations. Now, these data subject rights are being, I must say, the consumers are being more empowered under the CPRA in support of their data subject rights. And even, this fifth one, this data collection and this retention restrictions. Here again, this data collection, more importance has been given, so that at the time of collection, there should be very transparent and active consent from the part of the consumer. And insofar as this retention, which we commonly call as a storage limitation, that is, if you have collected the data, you cannot retain that even when the purpose is over. So the CPRA has brought another very important thing, that is, when you are collecting data from a consumer, you need to specify the very period till what you are going to retain the data. So again, at the time of constructing the compliance checklist, that would be another very important aspect. That is, there should be a process by which the consumer should be communicated. And another important thing regarding data collection, that again the data minimization concept has been brought in under CPRA. That is the minimum amount of data on the need, on the specific need basis, that need to be collected, not all the related data which are not strictly related for the, or strictly necessary for the business, that need not be collected. And the next one is very important, this profiling opt-out. This profiling is something which is the automated decision making. Just like, say, by analyzing somebody's transaction, banking transaction, a credit score of a person can be found out. Now, this profiling is something that may be credit score, that may be somebody's health trend or anything. So that CPRA has given much importance, that if you at all going to share that with somebody, there should be specific consent from that individual. Without that person's willingness, this profiling or automated decision, or this automated data, that cannot be shared. The seventh one, I'm for the interest of time, I'm just rushing a bit. So for the next one, this 30 days cure period. Again, this 30 days cure period was something which was in CCPA. That is when business has been notified that there had been some breach. So a 30 days time is allowed to that business to cure that irregularity. But that 30 days cure thing has been eliminated. So just to make business more responsible and more accountable to the personal information of the, of the California individuals. And this again, going back to Rohit, this data subject right, as you very correctly mentioned, again, this right to correct an inaccurate, and to correct the inaccurate personal data. Again, this is something, a very important aspect of GDPR that has been crafted under CPRA. And here the time is 45 days, within which that inaccurate personal information, if some data subject of or a California resident, they come across that there has been inaccurate data, wrong data already gone into or had been collected by the organization, that can be the consumer will have got every right to approach the organization and requesting to correct that. So the organization needs to do within 45 days time. And this fine and this this time, this for the minors data, if there is some breach, some irregularity in the minors data, they who are under the age of 16, initially it was to 2500 USD, that has been increased to 7500 USD. So that's again just to make the organization more responsive.
So I'll just add 2 cents on profiling. What it does is, it's a concept where we say that our personalities and choices are finite, and we try to recreate, the companies try to create the customer's persona using data and their decisions. For example, if you have been searching the web on certain days, then they would know, okay, this person buys this thing when the winter comes, and they'll be giving you those suggestions. They'll try to create a persona of you by collecting more and more data, and understanding more and more of your decisions. So moving to the next slide, which is about the checklist for CPRA compliance, which we had discussed at the beginning of the session. This is where this is a summary of the things which the company has to do to comply with the CPRA. So Ushur, would you like to take us through this?
Yeah. And thanks a lot, Rohit. Just bringing the most significant and the most important topic. And in fact, I was also chopping down this checklist. So just to start with, for this checklist, why I just would like to share that how this checklist is aligned with the respective rights which are being brought by CPRA. So just to start with, while preparing the checklist for the respective organizations, we can start with doing a gap analysis. A gap analysis is something which is applicable whenever there is a new legislation, new law is coming. So a gap analysis also identifies the respective gap into the practice and the proposed, and the proposed law and proposed suggestion from the law, as well as it also gives us a very clear idea about the action. So the next step, which I would like to prefer, that is to update the data management and the data governance system of the organization. Why? The reason being, we have already discussed in details about the data subjects rights. Some of the data subjects rights which are made very prominent under CPRA, like data minimization, like very active and willful consent at the very beginning of the collection. Retention, that whenever you are collecting the data, you need to give that for how long, how specific period for which you're going to retain the data. And the data subjects are, or rather these California residents are being given the right to get their data either deleted or getting corrected if there is an inaccurate data. So the very data governance and the very data management perspective or management set of the organization, that need to be reviewed from the perspective of these new data subjects rights which are being brought by CPRA. So I would be saying that as the second point of the checklist, it would be great if you can revise and review the entire data management and the data governance perspective of the organization. And the next one, I would be saying that, this privacy audit, this periodic privacy audit, particularly for the organization, they who are going to hold high risk data, like here, that may be the SPI, for them what to do. So since this audit is going to be a regular feature, a regular work, and the audit report, annual audit report, need to go to the new authority for their review. So this audit need to be crafted in the to-do list for the organization. The relevant stakeholders, they need to be roped in. This evidences in support of the audit observation, those need to be collected, those need to be curated, and those need to be kept handy, so that if those are being asked by the authority or the organization is in a position to furnish them quickly. And this entire audit map, that need to be crafted either by way of a policy document or by way of a written map. So these are the few things which I think would be very important, so that the organization is enabled to conduct that audit and to come up with the annual audit report for submission to the CPPA. Another very important aspect I will just mention here, which is here mentioned here at point 4, that is opt-in and opt-out. This opt-in and opt-out would be very important. The reason being, as you have seen, both sale and sharing has been brought within the 4 corners of the CPRA. So if a California resident is not giving consent for either selling or sharing his or her personal information, so in that case, this opt-in and opt-out mechanism should be there at the time when data is being collected. Either that, I have seen that these are also made as a part of the website itself. That is, in the website itself, or the portal itself, there is a mechanism where the particular resident can go and can click or can select that he or she is opting out not to share to the third parties. So that kind of mechanism should be in place. Another very important aspect, particularly for SPI, and this is more critical for the organization, they who are holding humongous volume of data. That is, whenever the resident or that California resident is saying to delete or to correct there should be sort of a surgical kind of mechanism that is the huge, out of the huge pool of data, that particular data is going to get corrected or going to get deleted. So that kind of mechanism, which is quite difficult, and there is a time gap, is the time period 45 days, and beyond that there may be regulators action against the organization. So this kind of a mechanism should be there. There should be one person need to be responsible, just like under GDPR they were called the DPO. So that kind of data privacy officer kind of, there should be somebody made responsible so that the person can be an interface between the organization and the regulator, so that this kind of data subject request can be very effectively handled, and if there is some demand that can be redressed fast. And three things, like here it comes at point 5, this retention requirement. As I said, now the CPRA says that at the time of collecting the data, you need to say that till how long you're going to retain. So that retention mechanism, say whenever you're collecting a data, there should be automated email or any kind of communication that need to go to the consumer that the data is going to be retained for this long period. So that need to be there. And what happens? The other side of retention is deletion. So it is not only the communication, but in practice, you have to do that. There may be some automated means to do so. That is, say you have stated something that after 1 year, the data is going to be deleted. So after 1 year, the data need to be also physically deleted. If not, there may be regulators action. And in US, the regulators action is quite harsh that way. The penalties are quite high. So we need to be, exercise highest caution on this.
And even
And
from the as a US culture, we say that it's just not the regulatory authorities that are after you. It is also the data subjects themselves with their legal rights and cases and pulling the companies to the court.
absolutely, what happens? In India, our jurisprudence is like that. This damage law is not that way very developed yet. But in India, the scenario is changing. But in US, the damage law is quite matured. And in US, for even a civil wrong or any consumer right, the quantum of damage is quite high. So that's a very difference between the jurisprudence of India and US. And so we need to be very careful about that high quantum of fine. And this breach response plan, now since, as we have seen under the SPI, that email messages, login credentials, all are coming within the fold of CPRA. Therefore, our breach response plan, that we also need to upgrade. That is, what may be a breach? What are the occasions? Generally, we find in our corporate that a wrong send is mostly the breach. That is, say, for example, I wanted to send the mail to Rahit Jain, but I have wrongly sent the mail to Rahit Agarwal. So that's the normal we find that in the corporate, there's a kind of a breach, and mostly those are, due to inadvertent error that happens. But here, since the login credential has come within the four corners of CPRA, we need to be very, very careful that whether what is going to be the threshold, what is going to be the trigger for that kind of a breach, and breach response we need to be very thoughtful of, very careful of. So Rohit, for this, if you have anything to say, or we can move on to the next slide, as
Yeah,
because
I'll just
CPRA
add.
has brought so many things to discuss, but within 1 hour, it is very difficult to touch base everything.
But I really appreciate your enthusiasm, Ujjwal, because this is going it's going like a deep dive session into CPRA, and it's very knowledgeable. We are talking about things like reporting, generating reports, and how security is a main concern, the data governance part of it, how the data governance program will slowly become something regular for the industry. Guys, if you think of data governance, it may seem like a far-fetched thing, and especially in India, not many companies have that program. But because of the privacy laws coming in, this will be a baseline which that has to come up. When we talk about data governance, it's realizing your data, building your data inventory, and then uh, building a organization wide framework which can be used in different programs. Privacy will be one of the programs which will leverage the the workings of data governance.
In fact, Rohit, I'm just tempted to say one thing. As you said, very important, this data governance is the overarching kind of an exercise. And that brings a good lot of things within its fold. As you said, this data inventory, the practical challenges we face every time. Say, for example, you received a data subject's request to delete data. Now, without a proper data inventory, most of the corporate will find they are struggling to find out that a particular data subject's information is stored where. You will find for an organization, it is very difficult to have effective control. That is, you will see that some of the information in the email, some of them in somebody's hard drive. So having our data inventory is very, very important part for a data governance program. And here, while framing this checklist, what with which we are all struggling, and perhaps with more inputs we get from the CPPA or some other regulators related to CPRA would be doing. But as a baseline, I can always suggest that it would be always good what we have tried to do here, that is to find out what are the rights and obligations which are arising out of the new law, that is CPRA here, how we are going to address or going to take care of them under a set of compliance checklist, and what is its manifestation, that ultimately the audit report which is going to the authority, and at the end of the day we get a clean audit observation from the authority, and now for 1 year we are safe from the penalty perspective.
Yeah. So I'll just add one more thing, guys, before moving to the next slide. Just to give you a relatable, example about data governance. Data discovery, we all know, we have all heard of it. Big ID, OneTrust, all the biggies have this tool. Data discovery is not a privacy operation. It is a data governance operation. So now you can relate to, okay, first we have to build that and then we move to privacy. So let me go to the next slide. And here comes a question. Which of the following rights are not part of CCPA? That is interesting now. So first of all, CCPA does provide some customer rights, user rights, data subjects right, whatever way you want to say that, but not all of them. So which of them are not part of it? And especially when it comes to because we were discussing about the audits and the reporting part, we see now earlier it used to happen that only the financial and the highly critical infrastructure organizations were in the purview of these audits and reports. But now even any organization which has a large chunk of data is being put under some sort of an audit, either a third party audit, if not a government audit, where they'll have to keep the reports ready. Okay, you are secure. Then how do you say, are you secure? The right to object to processing, that is not covered in CCPA. Is this correct?
No, this is absolutely correct. Right to object to processing is a concept under the GDPR, but at least we couldn't find that under the CPRA or CCPA.
So I think so. All the people have voted for the first one. Uh-uh. There is still inclination towards processing.
No,
Just be at yourself.
here we need to be mindful of one thing, that which is not a part of CCPA. The
Yep.
not thing is there.
I think so. We'll have to move. People say
Yes.
none of them are part of CCPA. We have a checklist for this. We'll go through that. I don't think so. They will surpass. Nobody is saying that. Everybody thinks that right to rectify data was always part of CCPA. So the new rights. I think so. This is uh,
We
what to
have
say.
already discussed.
Interesting.
Yes,
Yes, this is something interesting. But we'll just brief through this so that people can understand if they have voted right or wrong. Ujjwal, so we can just brush through the slides. If you want to
absolutely,
give us walk us through this, and
absolutely, absolutely. So, to start with, you see that as we have already mentioned, this data subjects right, which Rohit mentioned. So the first one, this right to correct inaccurate information, that's the data subject right, which can be exercised under CPRA. Then right to opt out of automated decision making, which I stressed on this profiling. So that is again something which is there. Right to access information about automated decision making. Again, this is quite close to this profiling. And the third one and the fourth one is the right to limit use and disclosure of sensitive personal information, which is very significant. First, we discussed about what are the sensitive personal information, and then we said that what the organization has said, CPRA has said, and what are the restrictions can be brought under the organization. So here we find that uh, restriction on processing of data, which is forming a part of GDPR, that is not here. So my understanding of the previous question was that that is stoppage of restriction of processing. That is something not under CPRA. Right to
yes,
rectify. If you see that right to object processing, right to limit use of SPDI, that is there. Right to rectify, it is the right to rectify is as a data subject's right. Right to limit use of SPDI, here we call SPI, as because interestingly data, the word data is bit the European application. In US, we generally use it personal information. So right to limit use of SPI is there, and right to object the processing, that is not specifically mentioned under CPRA.
for the answer, it is the first one. All of them, none of them are under CCPA even. So I think
Yeah,
so. The momentum went in the right direction. So these are all the rights under CPRA. We'll just read through them. So if you want, you can go through that. Otherwise,
yeah.
I'll go through this
Rohit, in fact, if you
because
see that, you see for the interest of time, I think we're almost
yeah, we
top of
can
the
skip
screen.
this.
So we have discussed all of them that way. So
Yeah,
I think we can skip this.
we can skip this one. You're right.
And additional obligation, and additional obligation that we also have, just like collect only necessary sensitive data minimization, inform people the duration of the time, that is the data retention, that is retention period that need to be, inform people of the data is being sold, that is the opt out option, whether they can opt out from the data being sold as well as being shared also under CPRA. Ensuring that which data is being complies with, that is there, if there is SPI, then the special compliance would be required. Provide adequate protection and maintain a data inventory to track the data processing. Data inventory, the significance and importance of data inventory, Rohit has already highlighted, which forms a very integral part of the data governance process.
So, guys, this is already covered in the checklist in some
Yes.
form or the other. That is the what to say, the crux of everything. Yeah. But another question: what is the cure period for business under CPRA before the fines begin?
It's a tricky one.
Yeah, it's a tricky one. It's a very tricky one. EU citizens residing in California, their data falls under GDPR or does it fall under CPRA?
It's an interesting question. So you citizen residing in California. So here, see, if you citizen, look, if you see the very language of CPRA, that doesn't say the California national or California rather, you need not to be a national of California. If you are resident of California and your data is being breached due to any action of any business, they who are applicable or for to whom the CPR is applicable, certainly your grievance would be redressed under CPRA. That is no doubt about it. As because to get your grievance redressed under CPRA, you need not to be a California-born national. The law has said resident. That is, for the time being, you who is residing there, they would be also able to take benefit of the law. So I think if a EU citizen is residing in California, certainly the CPRA will come into his or her aid if there is a breach.
Yeah, makes sense. But looking at the trend, um, how the voting is going, I can feel that CPRA is literally a new element in the room. For GDPR, people know what it is, how it works, and CPRA is coming as a surprise. I think so. It will be discussed in the next one, so I'll give you the answer for this. But people are very diverged in their answers. Penalties for non-compliance, guys. No cure period has been provided till now. That's for the answer. Penalties. Would you like to go through them? Although we have already discussed them, but just to give them a crux
Significant.
that
Sorry, just say.
yeah, because we have already discussed that it has been
Yes.
increased from 2,500 to 2,500 uh, dollars. So, uh, but yeah, we can again go through it. For the interest of time, what we can say is, because numbers are always interesting, guys, but this we have already covered. So I think we can skip the slide. Or can
Only
do you
one
want to
thing,
add?
Rohit, only one thing I would like to say here, that is now for this determining this penalty, this CPPA, that is the newly formed institution for to administer CPRA, they will also have a very significant say on quantifying the penalty.
So, as Ujjwal mentioned, that power has been transferred from the Attorney General to a new authority, which is a five-member authority. The uh, so
It's a
those will be the
five-member
one.
authority, and that is going to be comprised of experts from the technology, from the legal, from the consumer right. Mostly these from the subject matter expert from these three segments, so that all the whatever the grievances, whatever the issues, those can be seen from a very holistic perspective.
So the difference between CCPA and CPRA. So we have summed up the differences in a form of a direct comparison, so that it would be easy to remember. Uh,
In fact, Rohit, one of the answer to the question is here.
Let me see which one is that.
Ah, the slide
So,
3 is here, the
yeah.
third point.
Oh, yes. Yes, 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 yes. So,
Anyway,
so
so we can sum up this one, Rohit.
yeah. So, guys, for the pursuing violations, CCPA says that the Attorney General can do it, but now we have the CPPA for that. That is California Privacy Protection Agency to do that. The rights of the citizens or the data subjects, they have been enhanced with quite a lot, and more rights have been added. The cure period, which was 30 days earlier, that has been not deleted, I would say, but yes, that is not applicable now under CPRA. So that was the earlier question where we were. That is the what Ujjwal was mentioning
Yeah.
to the question for the last. This is the answer for the last one, where we saw quite divergent views from the attendees. So it's good to see a knowledge session, a webinar going this deep, guys. Right? So please give us a like. This will be there on the YouTube. Please subscribe to the channel, and to give you a better view again of the direct comparison, these are the consumer rights which are there in CCPA and CPRA, and the new ones where you see across, there was one not included in CCPA and they have been added in CPRA. So is there any favorite Ujjwal of yours which we can pick up and discuss, that why it is to be added, or maybe it has to be enhanced still?
No, as I said at the very beginning and also in the middle, that the very object of CPRA had been threefold. That the first one is to abridge the technological advancement what has happened in between 2018, that is when CCPA came, and the 2023 when CPRA is ultimately going to take effect. That's one. Second, to enhance, to empower the California citizens and the households regarding the way their personal information is going to be dealt with by the businesses. And third one, which is quite related with the point two, that is to make the business responsible, that how they are going to deal with the data. And that is the reason why these data subjects rights, deletion right, retention right, automated, that restriction on SPI, restriction on onward transferring of SPI, this automate restriction on this profiling, why all these things have been brought into, so my suggestion to the privacy enthusiast we gathered this Friday morning is would be, it would be always good to analyze all the rights and obligations being brought by this act, and only to design your checklist on the basis of those rights and obligations, so that there is practically no gap between the suggestive aspects of the law and the checkpoint which we prepare for for our organizations. And the ultimate manifestation is going to be the audit report, the privacy audit report, which is a new thing, which is very critical from the governance perspective. And that audit report is not only to be kept with us, this audit report will go annually to the CPPA for their observation. And ultimately, for all the privacy professionals, for us, our ultimate reward would be that if we get a clean audit report or clean observation from CPPA on our year-long strategy of our year-long data-driven perspective initiative efforts. So this is, we may say, this in nutshell, what is going to be our task under CPRA.
Oh yes, more work. I like that environment more. It's a more chance to. It's a better chance to grow.
Absolutely.
So, so the last page did not fully, what to say, could not accommodate the whole checklist. So here we have three more of them: the right to processing, the limit of SPI, and a right for opt out. So we have already discussed this in the earlier session, but just to give you a direct comparison, which you can use. So with this, guys, we come to the end of our session, basically. So any questions? Let me just see the chat and see if there are any questions here. There is one question from Arvind. It says that, is the applicability of CPRA and CCPA same?
Basically same. However, some changes which have been brought, some amendments which have been brought here, I would just, at the cost of repetition, I would like to say one thing. But I find that there had been a good lot of confusion while I speak to some people on the CPRA, CCPA, CPRA episode. people to think that CPRA is something which is going to replace CCPA, but this is not the case here. Perhaps that's a distinction between the Indian legal system and the US legal system. What happens in India, say for example, there is a Companies Act. Now, just to bring changes to some parts of the Companies Act, there is an amending act. Say for example, the Amendment Act of 2021. Now the Amendment Act comes and separately we don't see that Amendment Act anymore. As because those changes are brought within the perspective or in the four corners of the main act itself. But here under the US legislation and more importantly, this being a ballot act. So here what is happening, CPRA and CPRA which came to amend some portions of CCPA that will coexist with CCPA. That is, none is being replaced, none is going. So both CCPA and CPRA will coexist. However, when you are going to read any provision of CCPA, we need to check with CPRA whether that provision have been enhanced or some threshold has been added or some changes have been brought to any specific section. As we mentioned that at the very beginning, like this number of consumers or number of households that has been brought from 50,000 to 1 lakh under CPRA. So that we need to check. But here, the CCPA is not going to get repealed or deleted. Both CCPA and CPRA will coexist. But our additional responsibility would be to check that what changes have been brought by CPRA. So this is the thing I just wanted to bring this up. So both act will coexist.
And it's a right thing to say that this is an enhancement of CCPA. It's an addendum. It's not a replacement. So you are right in that case, Ujjwal.
Absolutely.
And any more question, guys?
I think one question we got from Anish, that is the right to bring civil suit in case of breach. So Anish, this private legal action for any breach, that remains. It's my personal view. That remains, that if, look, the law gives a statutory remedy to a breach that may culminate into some penalty. But against a data, and particularly we need to remember one thing. The entire philosophy of this personal information, the entire philosophy of the privacy, that had come from human rights. So, and in jurisdictions like US, the individual right, the human right, these are given paramount interest. So according to me, to uphold somebody's individual right against a breach, his or her right to bring a court action, a civil suit, that would, or damage suit, that would always be there besides the penalty which is being prescribed under CPRA, which has been enhanced under CPRA. So the right to sue will remain. But certainly, when the court is going to take care of the right to sue, the court will certainly see that whether by this right to sue or by this suit, whether that particular litigant is going to gain what, or whether the compensation what the litigant is entitled to, whether that has already been sufficiently dealt under the law. So that kind of subjective analysis, subjective determination would be there in this kind of lawsuit. But again, since in US the this damage law is quite mature, so there may be some additional damages maybe awarded to the litigant.
Thanks for all the answers, Ujjwal. And it is literally an honor to have such a knowledgeable person on the webinar, and turning it into just not an introductory session, but a deep dive session where I am sure people must have learned a lot. Because for me also, you added a ton of it to my knowledge sphere. So it's always good. And guys, you can connect to him. We have put his LinkedIn profile link in the chat box, and we took his content. Don't worry. And if you can connect to me also, we have done that. And see you in the next webinar. And if you have any questions, you can reach out to me on LinkedIn directly. I will, or you have any suggestions for any next webinar that you want, or maybe you want a deep dive, you want a introductory session of maybe data governance, you did not understand that word, or you want something about profiling and how the next gen of social media will complete that profiling. Guys, if you want, you can read how metaverse will complete profiling in all sense. It will be a very it's a very interesting thing to read. You would see all avatars, everything, but in the end you'll give away the whole profile of yours, how you make your decisions to uh, the companies. Bye guys, and have a nice day. Ujjwal, would you like to add anything?
Just one line I would say that data, cybersecurity, social media, tech law, these are going to be the subjects of tomorrow. And we'll see that this, traditional litigation arbitration will go in phases. So I will request all the privacy enthusiasts gathered today that these are going to be the subjects of tomorrow. These are going to be the matter on which we, the privacy professional, the professional lawyers, we are going to brainstorm. So it's an invitation from myself, from Tsaaro. Just let us be gathering in this kind of webinar more and more. Let there be more interactive sessions. Let there be more exchange of views, and let us enrich ourselves.
Yeah.
Thank you. Thanks a lot.
Bye guys, and thanks for joining.